Okay, after the hearing, the vultures are out here praying. Vincent from. After hearing are done, all the vultures are out for sure. You getting this, Charlie? It's Canada for you.
Which is sooner than later, in part because of concern that my clients in the midst of trying to install boilers to heat the place, and the company will not go into the building unless there's some resolution of this dispute because they're concerned themselves. So we leave it as an order from here. Well, not to the judge's order extends. We'll have to look at it and see if the judge's order extends past today's hearing. And if not, then we have to write the court's request that while we wait the decision of Mr. County, that the court put something in place that will give private contractors comfort that they can do anything that would require to protect the building and ensure it's got one signature.
Mr. Douglas, you think that you were asked to reduce a possible order, I guess, for the had that on hand. Now we're waiting for 27. I know that your client is seeing this through sooner than later. Can you talk a little bit about this delay and how they're feeling on that?
Well, obviously, in part because of the concern about the heat and the fact there's work that has to be done inside the building. My client very much wanted this issue resolved sooner than later. But of course, we appreciate the Justice Boundary having carefully listened to evidence and asked the questions we think are appropriate for both sides. It may take some time in order to render a decision. We would, of course, have both sides and prepare draft orders that she could potentially sign today with written reasons to follow. But I appreciate that Justice Boundary decided it's appropriate to wait for this written reasons. And we'll do that.
There was some, you mentioned pointed questions, right? There was some back and forth, both for you and for Ms. Celeste about kind of the arguments you were putting forward. She nominated CPC to nail down on the fact that the rent was paid at $100,000. Those were kind of your 2 points. And she talked to Ms. Celeste. Do you have any comments around that you want to make then?
I don't think so. I think in the end, judges will, in the context of trying to get the best argument, best position and reasons out of parties, will make statements like that for an answer. And in the end, we'll have to wait and see if, in fact, the position taken by her today is reflected in a decision, a written decision. But obviously, if in fact Mrs. Conley has determined and will determine that there was no further rent beyond the one rent payment made, and in fact rent was due and owing, and in addition that there was a requirement to make 3 deposits totaling $100,000 by the 10th of August, and none of those deposits were made, we think that that would be sound of her to determine, because we think that's consistent with the evidence. We've seen nothing in any of the affidavits presented by the respondent to substantiate that there are either rent checks or bank drafts or rent or rather deposit checks or deposit drafts. We've seen nothing. I haven't seen it privately. I meant that in terms of the evidence before the court or outside the evidence of the court. I haven't seen anything. But, another way that the respondent was obviously dealt with that was to pay the money in court. We could have done it ahead of today's hearing. That wasn't done in the front or the deposit. Thank you very much. Thank you. Thanks.
I mean, I'm here for cross country. this information was for 8 hours, and the United States of Canada, important for the country, not just 25. And it's such a privilege to be able to advocate for their concerns, and we have full confidence in our honor at this court to discern the truth and render the right decision. And it really is a privilege, and that's why that we are
We asked Mr. Douglas about this, but I'm sure your clients are also eager for there to be some sort of resolution here. Now we're waiting again, and we're halfway across the country again. So, your thoughts on having to wait a little longer for a resolution?
It tells us that the Honorable Justice is thinking. She, Her Honor, was a lot unsure from this day, and I believe all of us in this lot, it's something that gives us occasion to celebrate that we let Her Honor with something to think about, to really answer the question and estimate the truth, and to see to it that justice is served for the state and so for all of the parties involved, for their families, because there were tons of families, and in this region and across Canada, who put their heart and soul into the embassy.
Justice Gomery nailed into a couple different things. One is asking about why rent wasn't paid, or why there wasn't evidence that rent had been paid in this $100,000, and also why there wasn't more of an explanation on what this verbal lease amounted to. Can you explain why that wasn't brought up in evidence or part of the investigation?
So, the court has a number of things to think about. Her Honor heard the submissions that there a lot happened here, right? And it's no secret that this is a very contentious area. It's no secret that there's been, a lot of, conflicts here in Ottawa, not just now, but for a long time now, right? And so, the picture was painted, and I trust that in all her wisdom, Justice Gomery will be able to discern, the truth, get to the bottom of what really happened, and come to the right decision. Obviously, we all know that there's conflict here, and that there's a lot of deep conflict in Ottawa in general for the past 6 months, I'd say.
But why were more details of this verbal agreement? If there was a verbal agreement, why wasn't that spelled out anywhere so people would know what was going on? So Justice Gomery would have an informed decision. Because all she can look at is the agreement of purchase and sale. She didn't have any details on this verbal agreement.
She does have, Her Honor does have a lot of information that was in before the court. There is a lot to look at. There is a testimony that was provided by the witness. There are affidavits. There, is factors. There is quite an extensive amount of information, and certainly Her Honor is more than capable of sifting through. You also know this is like at the 11th hour, an 11th-hour hearing, and
You were given 17 more days, though. You rightfully addressed that, and that's why the judge gave you more time, right? So I don't know that we can characterize this as an 11th hour.
Maybe not 11. Sorry, maybe I should say that. But you can appreciate that this is a lot to do in a very short amount of time. Certainly, that's not, certainly that's pretty obvious. And I think the United States of Canada did as much of it could, as time that it could, and the only is a lot of wisdom. So I have full, confidence in the court to get to the bottom of this and render the right decision.
Okay, just quickly, because you mentioned there's a lot of stuff to sift through. Again, why was none of that material about this verbal lease or this verbal agreement that was made? There is a lot of material there, but very, very little. We listened to 22 seconds of that audio recording today, right? So what do we have to go on about this verbal lease, and why wasn't that provided to the court?
Well, there was. like I said, Justice Gomery is a very wise justice, and Canadian judges in general have a good keen eye. I have full trust in cases in Canadian courts to render a good, a fair, reasonable decision.
I know you have a flight. Are you going to come back? I don't know if you would. When there's a decision, like how are you going to be advised of that?
So I would be, I'm like I said, in a little itty-bitty island, and I would certainly be appearing before Her Honor at any time that I'm requested. Je peux faire la communication en français?
Let's see. Thank you.
Yeah, I got it.
Okay. You want to
No, I got it. It's fine. OK.
Thank you.
Alors en français, vous avez demandé plusieurs fois pendant le contre-interrogatoire du propriétaire McDonald, vous êtes resté très pointu sur une seule question, les dates, combien de fois vous avez parlé. Pourquoi est-ce que vous n'êtes pas allé ailleurs dans votre interrogation? Pourquoi pas avoir posé des questions sur le verbal agreement comme tel, comme la juge vous a proposé?
C'est une question excellente. On n'avait que seulement 60 minutes et ça passe vraiment vite. Puis, Madame la Justice a expliqué pour les 60 minutes et c'est vraiment vite. Alors, l'information est là, on a fait l'interrogatoire, puis la Cour va faire une décision basée sur la preuve qui est devant la Cour. J'espère je pense qu'elle a écrit, elle n'a pas lancé une décision au aujourd'hui. Alors, c'est parce qu'elle va réfléchir j'espère que
Madame la juge, Gomery vous a à plusieurs fois demandé des précisions,
oui.
a dû même des fois vous corriger. Est-ce que,
Oui.
est-ce que vous étiez prêt pour l'audience d'aujourd'hui? Est-ce que vous aviez eu besoin de plus de temps?
Ben, il y avait plein de documents. Il y a beaucoup d'informations devant la Cour. Alors, c'est pas juste une question de la preuve disponible aujourd'hui. Madame la Justice va lire tous les documents. Alors, c'est vraiment devant la Cour. Il y a la preuve devant la Cour. Il y a tous les documents devant la Cour. Il y a la jurisprudence devant la Cour. Alors, la Cour doit baser la décision sur l'évidence, sur la preuve qui est devant la Cour. C'est pas juste une question d'un interrogatoire pour s'en
Les affidavits et les autres.
Oui, les affidavits, les documents, la jurisprudence. Il y a beaucoup d'informations. Alors, c'est pas juste l'interrogatoire. C'est l'interrogatoire. Normalement, devant les cours, souvent, les juges font les décisions avant qu'ils viennent à la cour.
Oui, OK. Pas cette fois-ci.
Pas cette fois. Non, pas cette fois.
Merci
Merci beaucoup.
Merci à vous.
Enchanté.
Bon retour.
Merci beaucoup. Si j'accepte le vol. Si c'est pas trop tard.
Oui.
Oui.
Madam, I'm from the U.S. media, and I went to law school myself. Wouldn't the acceptance of the $5,000 make the other part of the everything that went prior to that null and void and moot? You know, once he accepts that's his quiescence that he says that's okay. You know, wouldn't that make the all this stuff the opposite lawyers arguing just moot?
It's part of it.
Yeah.
I mean, it's part. She'll have to take that into.
Yeah, but you should have mentioned that maybe, don't you think?
That
By his acceptance of it, you know, his acquiescence, it's okay so many days after. You know, he accepted it inter alia, not inter alia. Ipso facto shows that he said that's okay. No?
Yeah, well, Justice Gomery knows she has the evidence before her. So.
I just asked Sonia and she agreed with me, you know.
Yeah, okay.
Anyways, all right, thank you. You did a fine job, though, I could say that.
Thank you. God bless.
I sent you my video. Yeah, and I sent it to you.
I'm sorry Diana had to put that in. It made sense, didn't it?